that was fascinating to me. It was interesting listening to Rob Walters, who's very thoughtful, clearly, as I said, a lawyer's lawyer, talk about some of his cases. But I found it really interesting to talk about kind of the legal issues, executive branch versus judicial, what's happening with all the executive orders and that sort of thing.
Yeah, we took a hard look at the Trump administration and previous administrations and how really the judicial rule in this country has evolved over the last few decades. I think it was fascinating to see, obviously, his wealth of experience in antitrust, talking about AT&T, LIV Golf, PGA Tour, and the work that he's done there, but then really equating some of that work back into his larger work, which is on the Constitution and the separation of powers.
And as you would expect, a very balanced approach with a lot to get out of it.
Incredibly insightful, highly discerning, and also someone who's been deeply involved locally, which I think is a great connection for us on this podcast, because his involvement in Dallas and really shaping the future of Dallas has been critical to the city.
Good listen.
Welcome to Intersections, where we take a multi-generational look at the critical issues facing America. Tom, today's going to be really fun.
It is going to be a great one. Rob Walters. Rob is a leader in everything that he's done. Been a leader in his law firm. He's been a leader in the legal community and in the local community here in Dallas. Mm-hmm. In addition to that, I'd probably call him a lawyer's lawyer. He has been, through his practice, involved in some of the highest profile cases within antitrust. View him as a constitutional law expert and is somebody that's respected in the law community. So I think this is going to be a great conversation. Rob, thanks for being with us.
Tom, thank you for having me. It's a real privilege. That's a badly overstated introduction, but I love what you guys are doing. You guys are doing some really great conversations, so thank you.
Terrific. Let's get into it. You've dedicated your life to law practice, as I said, kind of a lawyer's lawyer. What was the attraction to it? What got you engaged, interested, and decided to pursue that as your life?
So, it's interesting. I came of age sort of on the back end of the baby boom. And if you look at what happened in the 60s and the 70s, the law was a really critically important tool for social change and for in economic change. And I think, frankly, and Justice Scalia said this many times, in the 60s and 70s, a lot of our very best and brightest in our culture went into the law. I always found that to be intriguing. It was a vehicle for social and economic mobility, but it gave you an opportunity to live in the world of ideas in an intellectual construct, which I found fascinating. But you could also be part of a platform to do meaningful things. So it was sort of all wrapped up in that.
So how does someone from Gene Autry, Oklahoma,
and there really is a place called Gene Autry, Oklahoma.
It's a place.
There is absolutely a place called Gene Autry, Oklahoma. Yeah, it's a little.
You were born there.
I was born there. Being a little glib. So my father was a military Air Force pilot, and he had a distinguished career. And there's a place called Ardmore Air Force Base, and there's a little suburb called Gene Autry, and there's still a debate about whether the hospital is on the Gene Autry side or on the Ardmore side. And we lived there. I lived there all of about 25 or 30 days, and then we were off to Japan and Okinawa.
Oh, wow.
I bounced around the world. I went to 11 schools in 12 years as he took us around the world and around the country as part of his military career. So it was a little temporary, my stay in Gene Autry, but that was at least the genesis.
You were definitely a military kid.
Absolutely.
You then make it to the University of Texas, I think, for undergrad and law school. Give us some background on the University of Texas, but also give us an outlook on 2025 football season.
Oh, okay, great. So I will be there next Saturday in Columbus. We're going into
the shoe?
In the shoe, into the den of iniquity. We'll see how all that turns out. But yeah, I'll be part of the small contingent that is going into the shoe. The University of Texas is interesting. I grew up in a military family. There was almost an inevitability that if you did reasonably well as a kid, you would go into the military in some capacity. So I had appointments to the Air Force Academy, the Naval Academy. I had an ROTC scholarship to Princeton. And I looked at all those choices and I went to my father and I said, Dad, this is just not me. I really want to go more in this sort of law stuff. And he just sort of wiped his brow and said, that's great. And I said, why? He said, well, I think you'd make probably a pretty good general, but it's going to be hell getting there because you're not great with authority. And so I found this at the University of Texas. There's a wonderful little interdisciplinary program called the Plan 2 program. So if you thought about that wonderful liberal arts school in California where Tom went, Claremont McKenna, or a Williams or an Amherst or a Pomona, those kinds of schools, like taking one of those and plopping it in a big collegiate environment. So you could go to school in a place like that during the week and have the collegiate environment in the weekend. And it was also essentially free. I paid $4 a semester hour, $60 a semester to go to the University of Texas at a time when the state funded 80% of it. It's now down to 12%. That's a whole different conversation. And there's nothing like great big land grant universities for economic and social mobility. And I was a beneficiary of that phenomenon.
So go back, and I'm fascinated. So appointments at both Naval and Air Force, and you had traveled the world. How did that kind of shape your worldview as you went into law school?
So, yeah, thanks for that. So there are two things about my upbringing that I found particularly meaningful. We spent a fair amount of time in Washington, D.C. And in the early 70s in Washington, D.C., it was a really, really interesting time. Watergate, Saturday Night Massacre, all the Vietnam War, all of those things. So worldwide events were the local news. And so that really gave me a perspective, a broader perspective than if you happen to grow up in a particular city or region, sort of out in the provinces. So that was meaningful to me. The other thing, and I think this is probably something a lot of folks don't focus on, is I think it's really valuable. I went to high school in England. I spent 3 years in England. I think it's enormously valuable to live an expat existence in some ways, because you are viewing your own country and the way you do things through the prism of somebody else's values and hierarchy. And so you get to ask questions like, well, how does our democracy compare to a parliamentary form of democracy? And how does our social welfare net compare to theirs? And how does our dedication to of our resources to national defense compare to theirs? And where should we be turning on the knobs in a way to get it right? I think it's a really important part of the rigor necessary to come up with a worldview that you're comfortable with.
That's fascinating, Rob, because yesterday I was in a conversation with someone in the UK, and we were talking about his view of American politics, and clearly very different than ours. And kind of you see that. And I think one of the dangers we here in the United States is we assume everybody thinks the way we do, which is not the case in the rest of the world.
No, and it's all a bunch of trade-offs. And that's why I think it's important to read The Economist, to periodically read the Financial Times in addition to, U.S. periodicals, because I think there are some really important perspectives. And it helps, as I think about things, you realize that we're not the be-all and end-all, and there are different perspectives and different ways of doing things. I think it's important context and perspective.
So left UT Law School, admitted to the bar right then. Then you went into kind of antitrust and kind of pursued that antitrust litigation, that sort of thing. Why that field?
I think it's a perfect intersection of law and economics and business, right? I mean, what informs antitrust is fundamentally economics, and I've always been fascinated with economics and business. So it's a really good interdisciplinary, multidisciplinary intersection of those things. And I found what I thought was the most wonderful lawyer on the planet, a fellow named Harry Reasoner, who was a lion of the antitrust and litigation bar. And I was very fortunate to be sort of a mentee of his. And so it felt right. And it was also at a time in antitrust, and it's really important in our nation's history, where we were migrating from what I thought was a little bit of a muddled view of the role of antitrust in our economy to one that was coming on with great clarity, largely as a result of the Chicago School, Richard Posner and Frank Easterbrook and other people, which gave us great clarity until the last 5 or 6 or 7 years, frankly, about the role of antitrust and maximizing efficiencies and consumer welfare. I think we've kind of gotten muddled up in the last 5 or 6, 7, 8 years and sort of returned to a little bit of the pre-Chicago School, which is a fascinating part of the ebb and flow of antitrust and its role in economic growth and economic vibrancy in the country.
Do we even have an antitrust direction today? I think of the social medias, the dominance there. I look at what seems to me from a non-legal standpoint, a lot of inconsistencies in the way that we're addressing a lot of the mergers and acquisitions, and even administration to administration in the space of a year, what might have been not prohibited or prohibited a year ago is now prohibited.
Yeah, it's a great question, Tom. And look, I mean, there's what business wants is certainty. What business wants is you deal them, we'll play them, but don't reshuffle the deck continually on us. And we're seeing this, and it's also manifesting itself in executive orders where, okay, automobile industry, you can do this for the next 4 years, and then it's going to swing back on our renewable policy or EV policy or whatever it is. And I think that there's a huge cost associated with that. That has been the case in antitrust, and I think it's a real problem. What happened about a decade ago, and it's people like Lena Khan who ran the FTC. There's been an effort to use the antitrust laws to achieve other objectives, other economic and social and political objectives. I think that gets us into a quagmire. I think the way we should be doing things is the antitrust laws should be dedicated first and foremost, really exclusively to maximizing economic efficiency, maximizing competition, and therefore consumer welfare. And if we have other political goals, let's achieve them with other tools. But let's not bludgeon things by using the antitrust tools and instrument for non-competition purposes.
Do you see any parallels between today's antitrust issues and 100 years ago?
Absolutely.
Standard Oil, back in the roaring 20s. Give us some thoughts on that.
Absolutely. And in fact, for a while there, for a long time, antitrust there's this notion of we want to protect small businesses at the expense of consumer welfare. And what do I mean by consumer welfare? I mean unvarnished, unmitigated competition. We're not picking winners and losers. It's all about the competitive enterprise because that's going to maximize wealth and consumer welfare. It's going to maximize. It's going to keep prices down and maximize production. What's happened is, and that all changed with the Chicago School into the 1980s and 90s and on, and we had this wonderful 30-year period where there was great clarity about that. I think we have retrenched, in my judgment, to where we're trying to, protect labor or protect small businesses or goals that really have nothing to do with what the antitrust laws ought to be attempting to achieve. So in that sense, I think it's
competition pricing, et cetera?
Competition pricing. I mean, I really don't think it's all that complicated. Antitrust laws ought to protect and enhance the competitive process and not pick winners and losers and let the chips fall where they may.
So Meta, Google, do these companies really truly have too much power?
Well, it depends. So I think it's interesting. So the monopolization, look, in this country, we're really paradoxical. We love to root people to the top. And once they get to the top, we love to tear them down, right? And so there's sort of that ethic that sort of underlies all this. It is the hardest problem in antitrust. When you get to be big and powerful and have a lot of clout, when's it okay and when's it's not? What are permissible practices and what are impermissible practices? And that's been the holy grail, the never-ending search in antitrust for a long, long time. My own judgment is there are breaks that make sense. It makes sense for, I don't care how big Meta is or Google is, as long as they're continuing to innovate and add to the commercial enterprise, the benefit of consumers. They can engage in some practices that, frankly, do cross the line and protect them against competition in ways that aren't good for consumers and good for innovation. It is a perpetual, and it's really, you got to examine it one case to the next, one situation to the next to see which side of the line you're on. So in that sense, there's absolutely nothing intrinsically wrong with size. It's really all about the devil's in the details, or how are they manifesting that size.
But the corollary to that, and your point is, does the technology world today meet the antitrust structure that we have in place? Said a different way, clearly definition of market is critical when you're looking at antitrust issues. But when we start looking now, unlike packaged cereals, when we start looking at how you define the market, in social media, does that technology even fit the antitrust structure we have today?
I actually think it does. I think the analytical framework is no different than if you're looking at Standard Oil or if you were looking at a widget manufacturer. The question is, do you have power over price as a dominant player in a particular market? So you got to look really hard at what the market is. That involves economic analysis of cross elasticities of demand. The traditional test is if you raise your prices by 5 or 10%, are you going to get much migration out of your industry? So I actually do think that market analysis is not a whole lot different for technology companies. We saw this starting really in the 90s with Microsoft coming forward. Then the question is do you look at what are they doing and are they quote unquote fair or unfair? Are they permissible or unpermissible tactics and techniques? Now, I will say the one difference a little bit is something called the networks effects, which is if as a consequence of the nature of the industry and there's a networks effects, you have to be particularly careful and really focus on, is that giving them sort of unfair competitive advantages that are inuring to our collective detriment, if that makes sense.
Yes, no, very much so. So I'm going to put you on the spot.
Mm-hmm.
Do you think that's the case? Have the Metas, have the Googles, have the Twitter, have they gone so far in terms of the leverage that they have today over not just the consumer, but their advertisers and bring that advertising revenue in, with a lot being said about really using that leverage over advertisers to the detriment of the advertising market? Okay. Have they gone too far?
Take Google, for example. And Google has been sort of they've been the object of the antitrust enforcers last administration, 2 administrations ago. So this is not something that varies by administration, which really on the Google issue. And you say, okay, what are they doing? Do they just have the better mousetrap and they're drawing these advertisers because it's a better mousetrap? Or are they engaging in these insidious exclusionary practices that are keeping the competition at bay in ways that are protecting their market share but aren't innovating and creating pro-consumer benefits? And I have to say, Tom, and I know it's not a very satisfactory answer for sort of the big conversation and the gestalt, but you got to look at it circumstance by circumstance. And so I think it varies based on what the practices they're engaging in. Here's the other thing that's really going on that I think is most interesting that I don't think people are generally aware of. Article 3 courts, the federal courts, really act as a buffer to the political swings in administrations. One administration says we're going to do X. Next administration says, no, we're going to abandon X. We're going to go a very different direction. Article 3 courts, and this is only one example of many in our country and our culture, really have acted as a buffer on that because the courts are saying, well, not so fast. That might be your policy, but we're interpreting the antitrust laws based on a long and storied tradition and genealogy of what we're trying to do. And so that's why a lot of times DOJ will race off and file a case and try to perpetuate a policy that they want to or promote a policy that they think is important, and they lose. They get their heads handed to them. So it's a really important part of the process. So we don't get wild swings. We get a modest, more predictable migration of the law.
Okay, let's pivot from the theoretical to the practical. Your client list in antitrust would be the envy of any antitrust lawyer. So we can't go through all of them, but 2 of them to me at least stick out. One was leading the AT&T trial against the Department of Justice. AT&T was expanding into Time Warner, social media, content, et cetera, et cetera. Department of Justice comes at them. You led that effort. Long trial, et cetera. Can you walk us kind of through that experience? Because it seems as a fascinating experience going against the Department of Justice, first of all, but on something that was not only large, but got in something that touches everybody. It's kind of CNN, everything we watch.
So it was a fascinating experience. And by the way, I'll tell you who led that effort. It was Randall Stephenson CEO of AT&T, and John Stankey, who is today the CEO, and a wonderful, really talented.
So how intimidating was it to be the lawyer and have the CEO of the firm sitting in the courtroom every single day? Well, Randall's told me he was in the courtroom every day.
He was, and let me tell you, and so was John Stankey, and it was somewhere between intimidating to irritating. And what I mean by that, and by the way, they threw themselves mind, body, and soul into it. I mean, when Randall testified, he wanted to be drilled over and over, and they really threw themselves into it. I will tell you, John Stankey had this big pack of yellow Post-it notes, right? And what's really irritating about it is they would write these questions, and we'd look at these questions as we were doing something, and we go, damn, that's a really good question, right? And so their instincts were impeccable. But after a while, we said, look, John, you get 5 a day, right? Here are your 5 little yellow Post-its, and you get 5 a day. So use them carefully and use them well. But no, they were just tremendous partners, and it was a really, really superb team, and I was only just a part of the team.
But walk us through that. You know, it ended up in a victory for you.
Yep.
But walk us through, I mean, what it's like to go against the Department of Justice?
Well, the Department of Justice is formidable, and look, I think, they had, 50 or 100 lawyers on this, and we had 50, 100 lawyers on this. We had a very talented team, though. David McAtee and Randall and John, they stitched together a really talented team. And, but the DOJ was formidable on it. I will say, and I try to be objective about this, and it's hard when you go through something like that. I think the case was misguided by DOJ. Remember, this was a case, it was a vertical merger, right, mm-hmm, which is fundamentally different than two competitors trying to merge. And so what they were saying is, gosh, AT&T, you can't acquire a content provider with your distribution mechanisms and pull those together. And you say, well,
because you have too much leverage in the market over other competitors.
Correct. And you say, well, why? And I think they really struggle with a coherent, it almost fell into the category of, it was a little bit of populist antitrust and populist economics, but in the end, when you put a really bright light on it, I think they really struggled to come up with a coherent theory about why this would be anti-competitive. In fact, I think we put a pretty compelling case together as it was good for competition, it was good for innovation, it was good for consumers, it was all those things that produced both revenue and cost synergies, Tom, which you're intimately aware of in your many, corporate leadership over the many years. And by the way, it was also an example where we had a wonderful judge who said, I'm kind of listening to you, DOJ, but I am an independent actor, and I'm looking to the law over the last 50 or 70 years, and I'm understanding what the standard is here, and there's no there. And it was really, I think, a really compelling win at the trial court. We all felt like sort of Eloise at the St. Regis. We lived up there for 9 months and, tried the case, which in itself was really a fascinating experience to be sort of in the epicenter of what was going on in Washington at the time. But that was the essence of it. I have a lot of admiration for AT&T and its leadership to say, you know what? Life is short. We're right about this. Maybe if we cut a deal, we could kind of get through this quicker and better. But they went at it. They spoke truth to power, and they prevailed.
So how do you feel, though, in a relatively short time after it? Again, I'm sure during that period of time, you put your heart and soul into it. I know you did. Mm-hmm. But for the most part, AT&T has unwound nearly all of that case.
Mm-hmm. So I think, look, and this is, Tom, you're going to be better at this than I am. this would be a good, Harvard Business School case study. My judgment is AT&T did the right thing to acquire Time Warner, and they did the right thing to divest Time Warner. The industrial logic of it is you create this, this vertical enterprise. Maybe the markets would then start to give AT&T stock a media multiple as opposed to a telecom multiple. It kind of got wobbly and went the other way. And they also, AT&T learned that as they ran into massive demands for capital investment and in their infrastructure, it was a better deployment of their resources. So you really have to admire AT&T's leadership, was say, that was then, made a lot of sense. We made some money on it, but things have changed, our priorities changed, and they turned on a dime. And I think if you look at what's happened with the company and the share price, it turns out to be their judgment was acquitted.
Sure.
Fascinating. Okay, let's talk a little golf.
Yeah.
Let's do that. PGA and LIV. I think everyone is decently aware of the split that LIV really drove, call it 3-ish years ago, taking some of the most notable names off the PGA Tour. Instead of just getting into what happened last 3 years, let's look forward. Is there a way for both sides to get back together? Is there a happy marriage, or is that an antitrust issue?
Well, it is both, and everybody's pulling their crystal ball out on this. I mean, I think there's no question there's a consensus that golf will rationalize over time, and you don't have to look that far. If you look at what happened with, let's just go back to the 60s. The AFL introduces, a new league, and they start bidding on players, and players' wages go way up. They introduce some innovations. There's a lot of creative destruction that's going on at the time, and ultimately they reconcile and they come together into what has evolved into the modern NFL. If you look at the ABA and the NBA, the same thing happened. And by the way, this is there's nothing that is more cathartic and more productive than competition. We wouldn't have a 3-point line today if it hadn't been for the ABA. We wouldn't have a lot of those things. Same thing happened there. One would think in golf some reconciliation along those lines would emerge, but I think the jury's out. What I would say is that golf as a game over the long term will be infinitely better for it. Are the teams, is that going to stick and work? Is it going to be a little like microcosms of the Ryder Cup in the international series? I mean, we don't know, but a pretty good chance of that. Are we really going to grow the game internationally? I think the introduction of LIV, we have seen that is clearly happening. I mean, before LIV came along, let's understand the average age of an NBA of a PGA Tour fan was 64 years old, and the ice cube was melting. And the post-Tiger era, things were not going well. There was no innovation in the game, and they were really struggling with what their future is. Frankly, and I'll just call it like I see it, that's a typical behavior of a monopolist that has nobody on their heels causing them to innovate, causing them to compete. And that's exactly what happened here.
So go for it.
I want to come at it a little bit different angle and go actually back to the start. Because clearly any client has the right to representation. I think that's built into law schools on day one. But this is an interesting one. It's not just LIV Golf. LIV Golf was fully funded and backed by the Saudi government. Saudi government at that time and currently has a, shall we say, checkered record on the human rights side. It appears our intelligence agencies would agree that the senior individuals in the Saudi government were involved in the killing of a journalist, all of those pieces. So what goes through your mind when you're approached to represent them when clearly one of the objectives of LIV Golf may be to change the reputation away from those very instances and reputation that I just outlined?
So there's a wonderful lawyer in Dallas named Jim Coleman, in a firm called Carrington Coleman. He's a wonderful trial lawyer, wonderful. And I just remember when I was a pup lawyer, him saying, Rob, their mamas raised them. We just represent them. And I'm being a little bit facetious there, but yeah, everybody, of course, is entitled to representation. I mean, it would be a weird legal system if that weren't the case. But let me really lean into this, and I think that first of all, it's not the Saudi government; it's their public investment fund, which is sovereign welfare fund. But it is. But I understand. But just as a technical matter.
Yeah.
But putting that issue aside, I think people really ought to look at the Kingdom of Saudi Arabia today compared to what it was 10 years ago, 15 years ago, 20 years ago. I think they all say, well, what is the fate of women in Saudi Arabia today? It has radically changed, and there are a number of things that are happened that are much more have been westernized. Now, understand, we also view it through the prism of our sort of imagined reality called Western culture, and there are others out there and view things a little differently. But I think the KSA, I think, is really trying to insinuate itself back into the fabric of the world, the Western world, its role in leadership. I frankly think it was a mistake geopolitically to dismiss them years ago as a pariah state. And I think there's actually a very prominent role for Saudi Arabia, and it's an ally of the United States in what the ultimate rationalization of Middle Eastern situations is. And so, I mean, you put all that together, combined with what our duties are as lawyers, and you say, yeah, of course they're entitled to representation.
Fascinating. Okay. Let's switch gears a little bit. Chevron Doctrine. Big case before the Supreme Court. I think it was decided within the last 6 months. Give us an overview of what the Chevron Doctrine was, what was decided, and then ultimately where the power shift moved away from the agencies back to the judicial system.
Yeah, so I think this is a fascinating issue. So the Chevron Doctrine, you have to have a little historical context. I think it was 1984. And ironically, and this is why it's really important to understand that as these issues migrate, they cut both ways. These are not pro-Republican issues and pro-Democrat, pro-conservative, pro-liberal. But in 1984, what the Supreme Court said at the behest of the Reagan administration is that there ought to be we ought to defer to the executive in terms of making rules and regulations to give effect to what Congress has enacted. And
so to give the executive branch agencies pretty wide realm in terms of setting policies and procedures within the context of the law.
Correct. And so the agencies would have expertise, right? And so the court said, yeah, we're going to defer to their expertise. But the court went further and said, we're actually going to defer to their legal interpretation. And so as long as what they're doing is not an unreasonable interpretation of what Congress enacted, we're good with it, okay? And over time, that gave the executive a whole lot of power. And whether it was a Democratic administration or Republican administration, interestingly, and what really started in the 90s and the aughts was, well, maybe the court went too far. Ironically, one of the purveyors of that view was Neil Gorsuch and Brett Kavanaugh and others. Ironically, Neil Gorsuch's mom was head of the EPA in 1984, which gave them a lot more power. But that's just sort of a little bit of a side story. And what this Supreme Court has said, we went too far. We should not be deferring to the agencies for the legal interpretation. The courts need to do that. Yeah, we can defer their technical expertise. And so they pulled this back. By the way, this is a really knotty problem. If you'd gone back to the Philadelphia Constitutional Convention and said, well, now, just so you guys know, we're going to be 350 million people in this highly complex technical, they couldn't have envisioned it. And so there's nothing about our constitutional scheme that says, how do you get from a generalized enactment by Congress into 1,000 different rules and regulations that give effect? And so we have filled that very important interstice through the courts and ultimately through the Chevron Doctrine, and now what the Supreme Court did recently in this Loper-Bright decision, which is to pull that authority back away from the executive. Really important issue.
But two implications of that, Rob. One is that it sounds like the court said to Congress, you got to do a better job. You can't just kind of throw a couple of words out there and let it go wherever it may go. And the second is it really puts enormous power back on the judiciary to determine a lot of these questions that are up in the air when rules get set.
Tom, you have it exactly right. One unintended or maybe intended consequence of the original Chevron decision, it really allowed Congress to abdicate. So Congress could sort of essentially pull back and say, we'll give you a few generalized words, you guys knock yourselves out, and give Congress plausible deniability when they get criticized for it. What's now got to happen is Congress needs to think differently about the way it legislates so that it can address a different landscape about what happens after they legislate. I will tell you, the Bipartisan Policy Commission, which is run by Margaret Spellings, which I think is a wonderful organization, commissioned a task force run by Heidi Heitkamp.
I've done work back there.
And Mel Martinez. I've had the privilege of serving on that task force. And what we did is came up with, I think, a very carefully crafted report that says to Congress, going forward, if you guys are really interested, serious about doing your jobs, this is the way you need to think about legislating. So that's been an outcome, and the jury's out on that. We'll see how all that plays out. On the giving power to the courts, the only thing I would take issue a little bit with is all we're really telling the courts is do what you do in every other context. Interpret the law. Don't defer to an agency's interpretation of the law. And so we are just saying to the courts, that is your domain. That's your Article 3 responsibility. It's important as part of our overall separation of powers construct. And so do your job. That's what Loper Bright does.
Okay, Kyle got us on the diving board. I'm going to push us into the pool. Because clearly, Rob, your background, you talked about your early days in Washington, kind of seeing all that evolution. You've lived a life that's been focused on regulatory issues, on issues executive branch versus judicial, et cetera. Let's jump there. As you look at the judiciary today, is it still independent, or has it become so politicized? And I'm thinking of the last 3 Supreme Court nominations, but also all of the jockeying when you get to the district court and the appellate court nets. Has that become so politicized that the court no longer is, as you just pointed out, kind of that objective player to make decisions in the wider playing field?
Yep. So this really is such an important question about the judiciary. So if you think about independence as being a check against abuses of power by the executive or excesses in other ways, yes, the courts are clearly independent in that sense, and they continue to play and maybe, frankly, have enhanced their roles as being a check. I think of today as one of the most fascinating times in our history. This issue has come up in big ways along the way. It came up literally initially with Marbury versus Madison and giving the courts the right to interpret law. Okay, that was the seminal act. It came up in the Jacksonian period. It came up in the Civil War and immediate aftermath of the Civil War in important ways. It really came up in the 30s and the New Deal as FDR was unhappy with the constraints that the courts were imposing on his New Deal initiatives. It manifested itself in Watergate in the early 70s, and it is back in a big, big way today. So it is the latest iteration. I actually consider it to be the issue of our times. Now, to answer your question, which is, have the courts been politicized? They've always been somewhat political, right? I mean, there's been the legal theory on this is sort of the critical legal studies movement, which was very prominent in the 80s, which is, yeah, we're all judicial realists, right? And it's all about what did the judge have for breakfast? And there's always a political gloss to this. I think we have to be ever vigilant to resist that and to fight that. But yeah, and I think frankly, the mainstream, the media on both sides and all around has played a really bad role on this as they conflate the two. They say, well, that was a Biden appointee. Of course you're going to vote for, or that was a Trump appointee. Of course they're going to vote in that way. I think that's overstated. I think there are, in the main, judges try to view these issues as best they can. They all have biases. We all have biases, but try to view it sort of through the Rawlsian veil of ignorance, if you will, or through the application of neutral principle to fact so that the result is not the ultimate objective, but is the application of the principle. And I still believe, and maybe I'm a little naive, but I still believe that in the main, that's what our courts are doing.
So you say it's back.
Mm-hmm.
Was there a tipping point within the last decade where you saw this really take a turn? Because I would say if I look back on the Biden administration and the first Trump administration, everybody's running to their safe, district court judges, 587 of them total, but they're running their safe district court judges to get a ruling or an injunction to stop the other side from doing something. Was that a first Trump administration situation? Did you feel like that started under Obama?
So
where did that come back?
I actually think there's a larger context for this. I think where it really got elevated was with Roe in 1973. When people looked at that and they said, boy, that's just a political play. I mean, look, we might be highly sympathetic with what the cause is and the issues about reproductive rights and all that.
E.g., the privacy was never in the Constitution.
But if you look at the Constitution and you can squeeze a lemon on the Constitution, no words come up and say there's a right of privacy in the Constitution. And so that was sort of the beginning of the repoliticization, Now, I would say if you lived in the 30s, you'd say the same thing happened then. And then fast forward. I think that when you look at the Bork hearing in 1987, and you look at the Thomas hearings, heavily politicized, okay? Fast forward even more than that, and you'd say over the last 20 years, nationwide injunctions were giving district courts huge power over policy. That was a relatively new phenomenon that both parties, both sides of political ends of the political spectrum, sought to exploit, whether it was in the Bush administration, so where it really kind of started, Obama administration really came on strong, and Trump and Biden is very prominent today. That's all been corrected, I think, by the Supreme Court by saying we're not going to have nationwide injunctions. The other thing that people don't pay that much attention to was in 2017, the Republicans said, okay, we're going to invoke a nuclear option on judicial confirmations. It's not going to require 60 votes. It's going to require 50 votes. Well, guess what? When it requires 60 votes, you're going to put, it's the judicial analog to gerrymandering. We're going to push this to, you got to be more moderate if you're going to get 60 votes. Look at the votes. I think Gorsuch got 53 votes. Kavanaugh got 50. Jackson got 53 votes. It's not clear to me that any of them would have made it through the gauntlet if 60 votes were required. There was a real consequence of that break, and both parties are perfectly understandably, it'd be irrational if they didn't, exploiting that lower barrier.
But isn't that really the difference? I mean, you talk about that. 2017 is pretty recent. It's kind of what I'll call in this political sphere. You talked about the FDR situation, but the FDR situation, when he ran in the courts, he was able to have dominant majorities in both of the houses. So that New Deal legislation was passed. This situation, you're not going to have legislation passed. Right. So as a result, this administration, in ways that we have never seen before, is using executive orders. How do you look at the balance of power, judicial, congressional, judicial, legislative, and executive, when you look at the balance of power of what's happening in Washington now with the use of executive orders, and we'll get into some of the details, but everything from immigration to universities.
Yep. So let's give a little historical context, because I think we're being misled a little bit today by the popular press on the use of We have had, I think the numbers are, Trump had, I think, 220 executive orders in his first administration. He's got like 150 so far, okay? Obama had about 300. Bush had about 250. How many do you think FDR had? 3,500 executive orders. How many do you think Eisenhower had? 500 executive orders. Now, I will tell you, I think the issues they're applied to have become a little different and more prominent, so I will grant you that. But this is a long and storied tradition. If you go back to FDR, he was extremely frustrated by the Supreme Court. He wanted to pack the court, right, in order to obviate that. And that court really put some real constraints on him. If you think about very famous decision, Humphrey's executor about, and it's an issue that's coming up today, is there such a thing as an independent agency? Or are they just the tools of the executive under our constitutional scheme? Is Jay Powell, is he entitled to independence? Is the FTC entitled to independence? Those are precisely the same issues that FDR encountered in the 30s. Now, to really answer your question about how are E.O.s being deployed today, extraordinarily aggressively. This administration, in my judgment, is pushing the edge of the envelope. And I think it's giving rise to two phenomena that are really important. One is, how are the courts reacting to executive orders? And how is that making its way through the system? In my judgment, perhaps the most important person today in our history, as history will look back on it, is John Roberts. And John Roberts, in my judgment, his entire life has been orchestrated in a way to address this separation of powers. And you just watch the way the Supreme Court, the issues they inject themselves into and the issues that they defer from and the messaging they're sending. that's all about this dance, this dialectic between Article 3 courts, Article 1 executive, and how is that balance of separation of power going to manifest itself? I think it's really the issue of our times.
But when I look across what has been done with these executive orders, and you said the numbers, but to be fair, we're only into this 6 months.
Correct.
So again, very aggressive use of executive orders.
Yes.
In ways that I don't think we've seen. Clearly, USAID was one.
Mm-hmm.
The layoffs in a variety of different agencies,
Mm-hmm.
the way it's been used on immigration, of deportations. In each of those cases that I've outlined,
Mm-hmm.
big implications for the nation. In each of those, a district court, in some cases, several district courts, stepped in to prevent the action.
Mm-hmm.
Subsequently, however, in each of those cases, the Supreme Court has allowed that.
Mm-hmm.
Most recently,
Yes.
allowing the staff layoffs at State Department, I think several others too. So, Rob, how do you look at that? Because it seems like there's a real inconsistency of, one, the administration, again, using these for pushes into areas of power that we haven't seen. Two is district judges stepping in. And I want to ask kind of the inherent question of, should 1 out of 587 judges overrule 50 million voters? And then the third aspect is, appears the Supreme Court is kind of pushing against these district court judges and even the appellate court judges, although I think the appellates are tending to move towards the Supreme Court. How do you view this today?
Okay, there's a lot wrapped up in your question. Yeah, and so several things I think are going on. There's no question about E.O.s are really aggressive in really important, critical aspects.
And to be fair, to take power into the executive branch.
Yeah, there's no question about it. So the way I think it's working and the system ought to work is, I mean, the more things change, the more they stay the same. What the courts are purporting to do is they look at that and they say, does the executive have the power to do that? And it's derived from one of two sources. Either the Constitution gives them the right to do that, the executive, or Congress has. And if they haven't, then they have enjoined it, and primarily at district court level. Now, there is no question there's a lot of forum shopping going on, right? If you want to resist those, you're going to go to judges that you think are going to be sympathetic to you. By the way, that's exactly what what the Republicans did in the Biden administration, is they went off to whatever single judge jurisdiction in order to try to get the result that they wanted. Now, one thing I think is really positive is a single district judge, to the question about, do you have the ability to overrule 50 million people? I mean, that sort of begs the question, well, yeah, you do if Congress or the Constitution doesn't give you authority, right? I mean, it's sort of like, well, the 50 million people don't have the authority. They only have the authority through their elected representatives enacted into positive legislation. The other thing they have done, the Supreme Court recently did this, is say this notion of nationwide injunctions. No, you guys, courts deal with specific parties, cases or controversies. You can rule on that, but you're not going to give effect to policy through nationwide injunctions. But on that,
it looks like that didn't have any effect, because all they did then is basically take the court, the court decision, and run and say, okay, I will go ahead and certify a class action. Therefore, I can make a decision on class action. Therefore, I can do it on a national basis, even though I'm a district court judge.
There's no question that is a way an effort to wire around it. But the Supreme Court said that's in our rules. You have class actions, and if it meets,
do you think they'll come back at some point and limit that?
Class actions have already been limited in substantial ways over the last 20 years, where we've sort of rolled it back. But look, that's just the deal. If you meet a class standard, then you're going to have an effect to entire class. If you don't, you don't. And so I think it's an intellectually honest way that the Supreme Court has approached this issue. But the real underlying issue is, how does this ultimately make its way into a check on excessive executive power? And I think the way the Supreme Court is dealing with that is they're not letting these decisions sit for 2 or 3 or 4 years. They're using their emergency docket. They're all the tools in its toolbox to act on the ones that they think are the most egregious. And again, I think that's John Roberts and the court's leadership around that issue. And there's a lot to be written there. And I think they've been acting quite deftly in the issues they picked up and the messaging they've been sending. I think the other really important issue, and the story's not entirely written on this, is how is this administration going to react to that? Is it going to honor those ultimate edicts? Supreme Court doesn't have an army. Supreme Court has a bully pulpit. It has the power of persuasion, and it can't migrate too far away from public opinion lest it marginalize itself. And I think the jury's still out on that issue. Some would say, for example, in the Abrego Garcia decision, right, that the administration really looked the other way and didn't adhere to the judicial edict on that.
Deportation.
The deportation, right? Because it was sort of like, well, the plane's already in the air kind of issue.
Yeah.
Others would say, no, if you really look carefully at the administration, they might grouse and bang their feet and carry on about it. But in the end, they're respecting the separation of powers. That, in my judgment, is among the handful of the most important and pivotal issues we are right in the middle of.
Well, and I want to take this a little step further, because I think where this Trump administration, and specifically President Trump, has gone a little bit further is in his first 7-8 months of being in office. He's not only got after, separation of the powers, but he's also gone after corporate leadership of private institutions, private companies. So if I think about the Intel CEO and the Goldman Sachs economist, calling for their, either firing or their removal, or if you look at the Bureau of Labor Statistics, I mean, when he doesn't like something, he seems to take action. Has he taken a step too far of entering into the private world and not just kind of sticking with what he knows in the government?
There's no question that he and his team are seeking to exploit, at least in my judgment, all the leverage that they possibly can, and are going places that we have not seen before. Which, by the way, it gets a really interesting discussion about rule of law. I used to think that law mattered more and norms mattered less. I've really migrated on that. I think there are cultural norms that we have operated under, understandings that have been really important to the vibrancy of culture that I underestimated in the past. And I think he has busted a bunch of those norms. I think in the case of private industry, it's also interesting that I think our administration, it really goes back to our antitrust discussion that we had. I remember in the 80s, I mean, look, Japan, it was Japan Inc. It was a mercantilist, export-oriented economy. China looked at that and said, that's a pretty good gig. And they have picked up on that and done exactly the same thing in order to subsidize employment and their other goals. There's a great school of thought that said, well, you know what? The United States needs to be a little more mercantilist as well, which then manifests itself into either tariffs or the Semiconductor Act or the Infrastructure Act. Or there are things that we need to protect that are geopolitically important industries that we don't want to just let, just be subject to the forces of worldwide, international, global competition. All the things that he is doing, whether it's tariffs or whether it's, trying to cut a deal for 10% of Intel or whatever it is, in my judgment, are arguably about the business of how do you create a USA Inc. that becomes a competitive enterprise versus a China Inc. And by the way, that's not an unimportant issue. Ross Perot in 1992 warned against this and that great sucking sound. And a lot of people would say, look, we went too far. I mean, the sort of the world is flat, Friedman-esque view of the world, we went too far migrating to just consummate for fixation, almost a myopic fixation on efficiency as opposed to maybe protecting our labor forces in some fashion and protecting those industries that are necessary to geopolitical strength and prominence, whether that be rare earth or whether that be munitions or whatever it is. And I think a lot of people would say the reason that we have the sort of the populism of what we are currently encountering is we migrated that way too far.
There's a strategic component to it.
Hugely important strategic component to it. And I think we have to be really thoughtful about where we calibrate. My own judgment is no more than necessary around critically important geopolitical or industries that go into our geopolitical primaries, because otherwise you find yourself into sort of just crony capitalism.
Okay, but then the question becomes, how far do you go? So I'll take another example.
Sure.
We have seen the administration over the course of the last several months take positions with universities that have not only gone at some of the policies, which my guess is we could agree that some of those policies at universities have clearly gone too far, but now gone in to almost dictate curriculums, hiring policies, et cetera. So kind of put all of these together, Rob. Is the government intruding? And again, from an antitrust expert, antitrust is based on private markets working, allocating capital, providing innovation, et cetera, those sorts of things. Just from where you sit, is the government going too far into our economy?
In my judgment, my own personal, parochial, here diplomat without portfolio judgment, the answer is yes. If you take the universities, look, a key piece of our overall competitiveness over the last 70, 80 years has been an unbelievable innovation in R&D that we generate through a mechanism of funding R&D in the universities. I think we're cutting into muscle and bone by using that as a leverage point to try to achieve objectives with the universities. So I think it is way overboard. Now, does that mean the administration can't come in and say, well, the Supreme Court just said race-neutral admissions, you're not doing it, we're suing you to try to correct that? Perfectly fair debate. Yeah. But to try to leverage a bunch of results through the deployment of, like R&D leverage, and so I think some of the universities are saying, no, we're not going there, and we're pushing back, is a perfectly fair debate.
Most universities agree. Most universities now are paying the money. It hasn't been finalized, but it appears Harvard is finalizing a settlement for $500 million that will get them back on it.
Yeah, and I think that, so I think in my judgment, the administration is over deploying that leverage to achieve those results. Because in the university environment, because this is really not all that complicated, right? University it has to adhere to law, and they have to adhere to requirements by taking these R&Ds. If they don't, then they are going to be vulnerable. If they do, then they should not be vulnerable, because there's another really important principle at work here. And this is where I find that there's a sort of a hypocrisy going on with the administration on these issues, which is they were complaining that, you violated law through sort of the perpetuation of some of these ideologies, anti-Semitism, racial discrimination, and they said, we're going after that. That does not entitle them to say, but, we actually have an ideological view of the way, and we want to put that imprint on the universities. That is a bridge too far, because there is something very important at work here, and it's called the First Amendment. And it is called, it is all of that, the academic freedom that is associated with the First Amendment, that we would be disserved if we went into university and say, no, you got to look this way ideologically.
So, Rob, we've talked about the Trump administration going after universities, private industries, but also law firms. Give us a little background on what they've done and where that goes.
Yeah, so I think this fits in the category of universities and business and how the Trump administration is seeking to maximize their leverage. My own personal judgment on it is that it is beyond the pale. Look, if law firms are violating law or violating anti-discrimination, fine, then go after law firms like any other citizen and seek to enforce law. But in my judgment, they've gone well beyond that in order to they are trying to exploit leverage over law firms in order to coax impermissible behavior and encroach on the rights of law firms to represent clients, to exercise their First Amendment rights, and all of those things, their rights to equal protection. And I will tell you, I really admire the law firms that have fought back and have said, no, life is short. You guys are trying to extract some results that you're not entitled to, and we're going to fight back. And guess what? Every major law firm that has said no mas and has gone into court has achieved a successful result. And the Trump administration, the results have been that you guys are indeed, through these E.O.s around law firms, violating our First Amendment rights and violating constitutional standards and violating laws. So I think it's just yet one more example, but it's a really important crucible for in which this issue is playing out.
Some of the law firms early on, though, settled.
Mm-hmm.
Wrong strategic decision.
Oh, I think, look, I don't want to be presumptuous. I think every law firm's got to make their own judgments, like every university's got to make their own judgments. Remember, at the time, they were having clients say to them, look, we love you guys to death, but you can't be effective, so we got to go elsewhere. And they are, they're professions, but they're businesses too. But having said that, I really do admire the law firms who have said, we're not gonna abide by that. We're gonna fight back. And again, every single one of them has acquitted themselves very well in the courts and have been successful.
So, where we've gone over the last several minutes, shift in power, major shift in power to the executive branch, challenges in the balance of power between the judiciary and between the executive branch, and the executive branch getting into areas of private enterprise. So, this administration is going to end in 3.5 years, plus or minus. Talk a little bit about all these issues, how they play out, of where you see this impacting our nation, not in the next 6 months, but in the next 10 years or 20 years.
So
how does it change our country?
Yeah. So I'm an optimist, and some would say perhaps naive on this. I'm certainly not a fatalist by any stretch of the imagination. I think we're going to get through this, and I think we're going to get through this fine. And I think that it is the silver lining here is because if you look at historically what happened in, Jacksonian days and different ways along the country, we've had some really, really, really existential struggles that we have gotten through and have made us better and stronger. I really hope that we view this as an opportunity to institutionally, culturally focus on what we have in common and not what separates us. And I think there are a lot of vehicles that we can use for that purpose. Now, I would say this. I worry that the gate swings one way on some important issues. When you criminalize some political behavior, it's a bad thing. Countries have done that. It's hard to put that genie back in the bottle. When you have if you start to ignore the separation of powers, it's hard to put that genie back in the bottle. When you politicize the courts, it's hard to put that genie back in the bottle. So I do worry that we strip some gears and that it's going to be more of a bare-knuckled fight in the future as a consequence of these things that we have done and that we've been talking about by politicizing a lot of these institutions. That's why it kind of comes full circle to say, I'm sorry, and I think it's going to be a big challenge that we have abrogated a lot of the norms that would drive us culturally.
That may be great closing comments, but I'm not going to let you close on that because it wouldn't be fair to not have you address as much, and I think you've demonstrated the strength of your legal understanding and how that applies to issues that are important to all of us. But all of the work that you've done, and I mentioned at the front, you've been a leader in your law firm as a former managing director here in Texas. You've led the practice of law much wider than that, but you've also been a leader in this community, and you put your time and resources into making our community better. You've served on the Citizens Council. You've led that. You've been the key player with a couple of others in Clyde Warren Park, some other efforts that have truly changed, transformed this community. Talk a little bit about how you view community service and the responsibility of each and every one of us to our communities.
Yeah, well, let me just start by saying, Tom, thank you for that. But my modest sort of peripheral efforts have paled by comparison to the great leaders of the city, and I count you among them and your public service. And we have a long and storied tradition here. If you look at people like Tom Luce, you, Jody Grant, others, and part of that is just our social compact. We have a lower tax base, a sort of predictable regulatory scheme, but that relies on, for the vibrancy of this region, to have a lot of public-private partnerships. And so it's an obligation, if we're interested in making past prologue and making the Texas Miracle and the North Texas Miracle continue, that we've got to have really strong public-private partnerships to make that work. And what we do know, and I think this is interesting, really interesting, what we do know, and most economists would tell us, what are the most important infrastructure investments you can make to ensure economic growth and vibrancy? It is, number one, interestingly, rule of law. The ability to enforce a contract. And number two, it is really hardcore investments in infrastructure, airport, parks, other things that drive economic return. If you look at Clyde Warren Park, city invested $20 million. Today, we're getting incremental tax revenues of almost $200 million a year. Right. That's the paradigmatic example. There are lots of examples around the city. So those are the things that are well worth doing. I personally believe, particularly in what I do and we have done as members of the legal profession, and I use that word profession in a very careful way. The profession historically had been theologians, doctors, and lawyers. What does that mean? That means a commitment beyond just profit maximizing. I take that responsibility seriously. I think everybody in our profession should. And what I love about this region is you can show up without pedigree, without anything. You can raise your hand and say, I'd like to contribute, and you are wildly embraced. That tradition, I think it's really important to cultivate and perpetuate. I think it's critical to ensure that we are going to continue this ascendancy. And on that issue, I really leave with a little bit of a warning, which is we have to be ever vigilant and ever rigorous. In 1904 in St. Louis, they were feeling pretty good about themselves. Second largest city in the world. They were a gateway to the West, and they were in pretty good shape. They took their pedal off the metal. In 1955 in Detroit, they were feeling pretty good about themselves. We have huge competitors. They're sitting in Oklahoma City and Chattanooga and other places around the country saying, how are we going to pick off those corporate interests? And so it is hugely important that our political leadership, first and foremost, but our civic leadership remains ever vigilant about that, because if we take our foot off the pedal on this, we will get our heads handed to us.
So you have led an effort to bring the downtown, I'll say, back, in the sense that we probably took our foot off the pedal, to be truthful with you, and saw some things that made it much more difficult for the downtown area in Dallas to thrive, which I think is important for the entire region to have that strong. There's no place in the world that is a strong city without a good, vibrant downtown. Talk about why you got involved in that effort and what you're hoping to accomplish.
Yep. So this I consider to be the most important issue confronting the city of Dallas today. And just sort of back up, big picture. COVID hits in 2000. There's no question that downtown was hurt worse than anyone. One, because our police efforts at the time was focusing on gang stuff and all that, which is great. But we didn't de-police downtown, but we certainly lessened it to a great extent. Downtown was certainly hurt by COVID more than anyone else because of people working from home and all that. And it very quickly slipped into a more dangerous place, the homelessness issue, all of that. Now, you look at that and you say, well, what to do about that? Historically, we always use the proposition as being, well, we either stay with status quo or we do better. That has all changed. We either do better or we're going to do far worse, and downtown is going to continue to atrophy. Why should we not let that happen? And it's three reasons. Number one, when you look at Dallas and you say, okay, what are our competitive advantages versus the rings on the tree, starting with whatever it is, Richardson or Prosper, McKinney, Allen, Argyle, go on. I mean, I drove to Oklahoma City the other day, and it's all the way to the Red River. In fact, the paper reported the other day, look at that technology belt that's going in around Sherman, okay? There's nothing that happens in Dallas that doesn't happen in those communities today, whether it's restaurants or whatever it is, or except for a vibrant urban core where people who want to live in a diverse environment, who want to have cultural attributes, who want to live with density, who have major league sports, who have places like Clyde Warren Park, that's our competitive advantage. So if we're going to stop the flow, we better get that right. Now, how do you get that right? The way you get that right is, and we've come up with a whole range of it. First and foremost, you get safety and security, but then you've got to do things like get the convention center just right. You've got to get universities down there. You got to keep the Mavs. You got to get entertainment right. You got to do all those things. Now, why is that important? It's for the same reason, and we BCG very helpfully looked at these issues and said, if you do that, you can take $4 billion of valuation downtown and you could turn it to 8 overnight. Think of the incremental tax revenues. Think of the ROI for a modest investment. And even more importantly, the growth prospects, the prospects for vibrancy in Dallas reside in our southern sector. 2/3 of our land, that's where the economic development, the increase in the tax base is going to come. That's going to be immeasurably more difficult if we allow downtown to atrophy, if we don't make it more vibrant. So for all of those reasons, I consider it to be an existential imperative for the city. Tom, I know I'm just sort of preaching to the converted because you did so much in your tenure to advance that. I just think post-COVID, we have slipped back and we got to get after it.
Well, your help on that is valuable.
Great. Rob, thank you.
Yep. I said at the outset, Rob, when I introduced you, you said it was kind. I think you have proved over the last hour that I clearly understated it. Rob, we appreciate you being with us. We appreciate everything you've done from the thought process that you shared today, but more importantly, everything you've contributed to your profession and to this community.
And thank you for what you're doing with this series. It's really, there are a lot of them out there. It's an extraordinary series you guys are doing. So congratulations. And Tom, thank you for your lifetime of contributions.
Appreciate it. Thanks for being with us, sir.